welcome. It says the title is If You Don't Have a Will, the State of Texas Has One For You, because that is our lifetime slogan, drives home the point. But we're going to talk a little bit high level today about things to know about wills, trusts, estate planning, and so forth. And then we're also going to talk about some special things that we're doing at Burch Law. Now, we are just limited to Texas. So if for any reason you're not in Texas or you have people that you want to get this done outside of Texas, reach out to us, because we do have a pretty good network throughout the country where we could possibly make recommendations for people who can do this in other states. But anyway, we will be talking about some new things that we're doing to hopefully help people get over the hump of not having this planning. More about that in a moment. So let's dive right in. Oh, this is what I was going to say before my video kind of went wonky, but perhaps just on my end. We are recording this, so we will be sending that. As far as questions, I am happy to answer questions. There will be question time at the end. You can either send them to, just put them in the general chat. You can send them privately to me or even Sarah. You'll see it says Sarah Gibson with Burch Law. Make sure that's the Sarah you send it to. And I will get to those. If I happen to catch it while I'm going through things and think it's something we should answer now, but go ahead and put it in there. I promise I will get to questions at least by the end of this presentation. All right, so, and do put in the chat if anybody sees any issues. I'm monitoring that with things that are going through here. All right, so what are you going to discover today? Well, here's what we're at a very high level going to go through. We're going to talk about what happens if you don't have any sort of estate plan, whether it's a will, a trust. And let's just say right out the gate, we say estate planning. I try to steer clear of that because it's misleading to some people. That is a will. A will is an estate plan. A trust is an estate plan. A medical, financial power of attorney is an estate plan. That is what's meant when you hear that terminology. So a lot of people will say, well, I don't have an estate. I don't need that. I just need a will or something like that. Like, we're all talking about the same thing. And if you have a bank account, if you have a car, if you have a home, if you have life insurance, you have an estate in the sense that you should put together a plan to make sure that it is going to be covered. We're also going to talk about a lot of the mistakes that we see, a lot of the pitfalls of, okay, I get it, we got to do something, but how do we do it right? And there's just so many downsides to trying to do it on yourself or online forums or some of these other legal programs. I know it sounds great, but we will talk more about that. We're going to talk about planning options and likely costs, and that's part of the special feature of this particular presentation today is the brand new Burch Law Choose Your Own Adventure Plan. So for those who might want to engage our firm for these services, we're going to learn about that as well. And then, like I said, you need to stay tuned for an exclusive limited time offer if you're ready to get started now. So before we dive in, like, who is Lorie Burch anyway? And why should you even listen to me? So I started this practice in 2005, specifically for people, specifically for wills, trusts, probate. We now have a really great team of people and attorneys that can help. We've expanded into business law matters. So we really try to be full service when it comes to things that affect what happens to your stuff, your people, the things you care about when you pass away. And the idea is really, our focus is really to give everybody from all walks of life, no matter who you are, the time and attention that the bigger law firms reserve for their highest net worth clients. And I really do enjoy educating people on this. And there's a lot of things. So hopefully if you're watching this or you add yourself to the registration, you will be getting more information from us that really sets us apart as far as what we do. And so I wanted to take a moment at the onset, because I think it sets the stage for the importance of talking about this stuff. So why do we do what we do? And I can summarize it this way, is that most, if not all, firms that I know that do this planning, they do it because they think wills, trusts, estate planning is important. We at Burch Law do this work because we believe you are important. Who you are, what you mean to the people you leave behind matters. What your family and loved ones will go through when you're gone matters. And on almost a daily basis, we see the pain, the anguish, and the sadness in the faces of our clients who have lost a loved one. They tell us how they're paralyzed with grief and overwhelmed with what to do. So yes, getting an estate plan in place is about legal documents, preserving wealth, what wealth you have, distributing assets, and the rest of what you typically hear. But that doesn't have to be all depressing and all doom and gloom. This is really a way to honor you, your story, and how you can create a legacy for your family. And so I want to take a moment and talk about what is a legacy. So in estate planning, we often talk about this being legacy planning. Why? Well, one of the definitions of legacy is an amount of money or property that someone leaves behind in their will or estate plan. And that's how most firms really think of this. But another definition, and our preferred definition of legacy, is the long lasting impact of someone's life or actions that you took during your lifetime. Now, your legacy could either be the long lasting impact of not creating a proper estate plan, or it could be the long lasting impact of your life. When you create an estate plan and you do it right, then your family will be able to focus on the story of your life and not the impact of leaving a mess. And your story truly is your legacy. So at Burch Law, that is our focus. That is our belief, that everyone from all walks of life deserve the dignity of a plan that will tell their story and honor their legacy. So if you will indulge me with a poem that I've brought this up a couple times, but I believe my mom first shared this with me when I was in high school, and it's something that has really stuck with me. And it's interesting now. I did not think in high school that I would be doing wills and trusts and estate planning. So now here I am. And I want you to really listen to this, because this is going to help really set the stage for what we're going to go through and what this planning is about. And some of you may have heard this. It's called the Dash Poem by Linda Ellis. And I'm actually going to stop sharing for a second so that that's not too distracting. But this is the dash. I read of a man who stood to speak at the funeral of a friend. He referred to the dates on the tombstone from the beginning to the end. He noted first came the date of birth and spoke the following date with tears. But he said what mattered most of all was the dash between the years. For that dash represents all the time they spent life on earth. And now only those who loved them know what that little line is worth. For it matters not how much we own, the cars, the house, the cash. What matters is how we live and love and how we spend our dash. So think long and hard. Are there things you'd like to change? For you never know how much time is left that can be rearranged. If you could just slow down enough to consider what's true and real, and always try to understand the way other people feel. Be less quick to anger and show more appreciation, and love the people in our lives like we've never loved before. If we treat each other with respect and more often wear a smile, remembering that this special dash might only last a little while. So while your eulogy is being read with your life's actions to rehash, would you be proud of the things they said about how you spent your dash? So I wanted to start with that because I think it's a really good segue that we've been talking about. Is like, this is for a lot of people not fun to think about, but when you're really trying to honor your family and put things in place that will help simplify things, make it better, you're really honoring who you are and you're honoring who they are. And I wanted to leave you or start you with that so that it sets a good tone for really what this is about and what we're going to talk about. So let's get back to our to the presentation and dive into our information here. So the question is, how do you want to be remembered? Here are some quotes that we hear, that we've heard, and that we continue to hear when you don't have a plan. I tried to get my mom to do this, but she just never wanted to talk about it. Now we're going to have to try and raise money to pay for probate since all her accounts are frozen. What do you mean I have to give half of everything to my stepkids? They didn't even talk to their dad. We had met with a lawyer, but we just thought it was too expensive at the time. And now I'm paying 3 times that much just to sort this mess out. We really thought an online will was better than nothing. I can't believe that it's not even valid, so we can't use it. I've been trying to get my husband to do this since our first child was born, but he didn't want to talk about it. I can't believe I'm in this position now to deal with all of this when I'm trying to grieve him and take care of our kids. That's the effect of not having this done and not having it done properly. So let's talk a little bit about what happens without a will, without an estate plan. Pay very close attention to this because this is a lot of stuff that people don't typically know. One, this is specific to Texas. It doesn't work this way in all states. So be aware if you have experienced something different somewhere else, that's because it's a different situation. But in Texas, your home and your assets do not automatically go to your spouse. That means even if your name is on the title of the home or you bought it together, if one of you passes, it's not automatically the surviving spouse's. We don't have that in Texas. It's called joint tenancy with rights to survivorship. There's ways to create it, but that's kind of the whole point of what we're talking about. There's got to be a plan. And this is why you need to talk to a qualified professional to walk you through. Is it a will? Is it a trust? Is it a transfer and death deed? Is it a ladybird deed? I mean, there's all these different options. Is it a survivorship agreement? But something else has to happen. Just the act of buying a home or being on a title is not going to make it automatically go to your spouse. That works the same thing with bank accounts. That works the same way with everything. So skipping around on the bullet points that you see in front of you, that also means in Texas in blended families, if your spouse or you have kids from a previous marriage or relationship, not only does the home, your half of the home and half of the assets not go to your surviving spouse, they'd actually go to your kids, meaning if you have lost your spouse and there's no plan or documentation or anything in place, you would be sharing your home, money, assets with your stepkids. And here's another kicker. If they are underage, and we see this play out all the time, a court is going to have to step in to appoint who will oversee them, who will oversee that for them. And they usually pick the other parent, meaning you can end up in a situation where you're co-managing money and your home and everything with your deceased spouse's ex-spouse. Okay, so it plays out all the time. It's wild. It blows people's minds, but that is what can happen. The other thing is a court is going to choose the guardian of your young kids and who will control any money for them. And that in and of itself sounds pretty bad, but let me tell you the reality of what this actually looks like. If you have not appointed a guardian, and I mean through a legal means, this is not telling your sister, oh yes, please take care of the kids. This is not designating them on an account. This is actually putting it together in a valid legal way. Your kids become wards of the state. They are in child protective services and they are in foster care until a judge decides who is best to take care of them. And if you're someone who doesn't think your family is the best, maybe it's a friend or somebody else, they aren't going to be on that list at all. So families can fight, they can argue, but even if they're all in agreement, the time and money and the trauma, frankly, that takes far outweigh what it would take to put a plan together now. Then once your child turns 18, for those of you who are parents, you lose any rights that you have to make medical decisions, financial decisions, or even have access to medical information. So what that means is for a lot of our clients who have kids going off to college or whatnot, 18, 19, 20 years old, they want to make sure that they can get some powers of attorney to make medical decisions and those type of things in place. We could go on and on about all the things that happen when you don't have a plan, but I wanted to hit some big ones. So let's talk about something else. Probate court. So this is what happens when someone doesn't have a will, doesn't have a plan, or even if they do have a will, there has to be a probate court process. Now, what that looks like largely depends on whether you have done something and whether you've done it right. So if you haven't done anything, then this can look like what's called a determination of heirship, where you have to get family members to all agree upon who can handle things. They have to pitch in money. We're going to have a chart in a moment. We love our chart here that goes through a lot of the different timelines and costs and everything. So that is coming. But there is a whole blown out procedure. A judge will appoint an attorney ad litem that has to research who your heirs, your kids, your marital history is. They have to get people who knew you that are willing to testify in a sworn statement that they knew what your assets and debts were. They knew all your marriages and relationships. They knew all your kids that you had, gave away, and kept. That is what happens. Now, you see that first bullet point there. Here's another big one. So we already talked about how home doesn't automatically go to a spouse and assets don't automatically go to a spouse necessarily. This is a big one. Even having a will, you still have to go through a probate court process. There still has to be a judge that approves it, says it's valid, and says that whoever you've named as the person to oversee things, the executor, is able to serve. More about that when we get to the chart, but you need to understand when we talk about different options, there's still going to be oversight, court oversight, delay, and expense, even with a will. It's a lot better. And spoiler alert, the best part of the will is you get to make all those decisions. So the things we're talking about, where the state of Texas decides who takes care of your kids, who gets your money, who this, that, and the other, the will is going to make all those decisions on your behalf. You have made all those decisions through your will. That's the point of the will. And it'll make probate simpler and more time effective, but it still is going to happen. And I'll tell you, if you've had experience with Texas probate, I've been going at this a couple decades now, and I can tell you probate in Texas had traditionally been somewhat easier by comparison to many other states. That has changed dramatically in the last 5+ years. There are just a lot more hoops that are having to be jumped through. Even with the most well-crafted will, there are time delays. And the fact of the matter is, very rarely do we have an ideal will situation. Either it's an online form, whether we can or can't use, it's out of date, out of state, or there's just a deficiency. It's only a copy, or it's been 4 years. These are all big things I'm throwing at really quickly to tell you, like, there can still be problems. So it's just become a lot more cumbersome. Again, there's going to be a chart coming up, but I wanted to talk about probate court because this is probably the most highly technical legal thing that we're going to talk about today. But one of the things you may have heard of is this thing called a revocable living trust. And that sounds super fancy. And I assure you that you don't need a top hat, a monocle to need this. A lot of people think it's based on how many assets or how much money you have. There are trusts out there that have to do with if you have a large estate or lots of different assets. That's not what this thing is for. This thing is for an option if you want to avoid that probate court process altogether. Again, the point of reaching out to a professional firm such as ours is we can tell you more of the nuance, but a lot of the advantages of the trust is that it speeds things up. This is all going to come together in a chart in a few slides, okay? It speeds things up because you skip probate, saves probate fees. It's not a public record because a will is a public record. If you have out-of-state property, you can quite often connect it to this trust, so you don't have to go through probate process and all of that. And if you are an adult and you ever have the onset of Alzheimer's, dementia, it can help avoid a expensive and nasty court-appointed guardianship for yourself because the trust actually can allow for who can kick in. The considerations, and again, the chart will go through this a little bit more, is typically a trust is a little bit more cost at the front end to set up to save a lot more later, but it is more to set up. That's not maintenance though. A lot of people will ask us, well, is there an ongoing fee? Like if I get a new bank account or this and that to put in the trust? No, there's not. It's more work to set up and maintain because the whole point of the trust is you have to get things connected to your trust. Now listen to this carefully too, because it'll be a good segue to the next section that we're going to talk about. And that is DIY forms, cut rate, legal plans. And this is one of the places where they fail you miserably, and why you need to go to a high quality law firm to do this is for a living trust to work, to avoid probate, have privacy, save time and money. Your assets have to be connected the right way to the trust. It's not like a will where you just sign it and you're done because it gets all sorted out through probate when you die. You got to make sure bank accounts are set up in the name of the trust. You got to make sure that your beneficiaries of life insurance, retirement are assigned the right way. You've got to make sure that real estate and maybe businesses even get assigned to the trust. And whether you do that and how you do that are all things that you need really intricate legal advice to do and assist you with. It's very important. It's not difficult, and you're not creating more time for yourself. If anything, you're saving time in the end, but there is work to a trust. There is. I put this one on here because this is something that we're sensitive to here. I'm just putting it out there for some people who try to get many law degrees. Many has, small law degrees when they're reviewing their estate planning documents. I'm just warning you, if you think wills have complicated legalese, the living trust is going to have more. But the way we try to approach with our clients is that we went to law school, so you didn't have to. So we have a really cool, unique system called the KISS system. Keep it simple, keep it super simple is how we do it. And we help you focus on the stuff where you made the decisions, and then you leave the legalese stuff to us. But I still put that there because it's just something that comes up with some regularity. Like, oh, this is so complicated. It's like, stop looking at that. You don't need to understand what that means. You still need a will. Okay, so you should always still have a will in conjunction with the living trust. Typically, this is called a pour over will, and it's in case, as I alluded to before, if there's an asset, a bank account, or something you didn't get connected to your trust, the will stands in to make sure that it will get put into your trust, but that doesn't avoid the probate process. So you really do try to avoid the will, but it's more protection. Okay. Again, that's the most highly technical legal thing we're going to talk about at this point. The rest of it is really for you to assess with an estate planning law firm, professional firm to work with. So let's talk about something that is near and dear to our hearts. And that is DIY forms, online kits, these programs that, oh, you sign up for this legal protection and you fill out a form and you get it, and lawyers look at it. Lawyers do that. Let me tell you something. Probate attorneys lick their chops at this kind of stuff because 99% of the time, listen to me, 99% of the time, that stuff fails one way or another. And we're about to talk about examples of how it does it. But they either are nothing or they make things worse than nothing by creating scenarios that you didn't really understand how it was written and all of that. So if the idea behind doing, the cheapest law firm, a DIY, these programs, anything like that is to save money, it'll save you money now, but it's going to cost a lot more money in the end. So if your goal is to actually make things less expensive and easier and not leave a mess, then this is one of the worst things you can do. I wish it was so great, but let me tell you a couple things too, is that when you go to some of these sites and they have all the testimonials are about how easy it was to fill out their forms and how inexpensive it was to get set up. Well, that's just at the front end. There's not a single testimonial that talks about how much money was saved by having this done when it was needed, when I had to probate the will or I had to do this or any of that. It's only how you get it done. But what matters is the results. Will it work? And will it work the most effectively for you? So let's transition into some of the ways this stuff fails that we see. One, they're rarely signed correctly. I know that seems wild, but let me tell you. So we are very, I would say, passionate about making sure that all these documents are signed, witnessed, notarized correctly. Every once in a while, we have people who need to do an offsite signing where, we're pretty well known and Texas is a big state. So we have people who aren't even in the Dallas-Fort Worth area that they want to get this done. That's fine. We're going to send you very detailed instructions on how to arrange the signing yourself. If you want us to even zoom in or FaceTime you and go through it, we will. We've done that. But what we always do is if you do that on your own, we have you scan it and send it back to us so we can review the signing so that you can fix it before it's too late. Because obviously with these DIY forms and online forms and self-help kind of stuff, you don't know it's too late or you don't know it's signed correctly till it's too late. So even with our instructions, our guidance and all of that, so often we see things signed incorrectly. I don't know why. I have a theory, not going to get into it now. If we wrap up early and you just really want to know, Lorie, what's your theory as to why legal documents don't get signed correctly without guidance? Like, I'll tell you. But people will miss a witness block or they'll not notarize it. Or we had a whole page that had a signature, 2 witnesses and a notary. And on the previous page, they filled it out, but on that page, they didn't. Like, I don't know what's going on. But if they are not signed correctly, they will not work. They do not exist. So understand that. There's no, oh, well, can't we just show it to the court or show it to the bank or this, that? No. The way it works is either it's signed correctly or it doesn't exist. That truly is the biggest problem that we see with them. The other issues that we've seen is they're not state specific. They don't have a lot of technical things like this independent administration thing. What does that mean? Don't worry about it, but it's something in Texas and you want your will to do that. There's no attorney accountability. I mean, one of my favorite things about these websites is they talk about how, one, they have no confidentiality that they owe to you. A law firm is going to owe confidentiality to you. Okay, so they if they lose your information, they get hacked, they get all of that. They also don't have any obligation to give you any specific advice, obviously, because you're just filling things out on your own. So there's none of that. The other thing, and this happens all the time, is there's the real world and there's the legal world. They don't always mesh. I can tell you in particular with what's called a financial power of attorney, where you give someone else the ability to go to banks, handle money, property for you. Financial institutions hate honoring these documents, even ones that are done with all T's crossed, all I's dotted. So I'm telling you that if you get a power of attorney done by Burch Law versus one online, you're just as likely to get a bank to tell you, nope, it's no good. The difference is when you've done it online, you're going to think, okay, well, maybe it's not. And two, you don't really have anybody you can call on the spot that's going to be able to advocate for you and explain it to them. On our side, though, you're going to think, well, gosh, I went to a firm that seemed like they knew what they were doing, so I don't think that's probably right, but let me call them. And I like to say, I always have to knock on wood somewhere, that we have a 100% success rate in explaining to banks and financial institutions how to honor these documents. So when we talk about attorney accountability, we're not just here to fill out documents. We aren't something I say sometimes like Mad Lib attorneys, where you just fill in the blanks. That's not what it is. It's the advice, it's the accountability, it's the customization, it's the thoroughness, it's understanding your specific needs and wishes, and then being there for you when and if something happens. The other big thing, and I want to harp on this a lot, beneficiaries on things like life insurance, investments, retirement function independently of a will or a trust. So when you're not getting the advice, and there's a lot of law firms like these cut rate law firms that don't tell you how to fill that out, then you may go and like fill something out one way and it completely contradicts. For example, you should never name a minor child, a child under 18 years of age, maybe older actually, but you should never name an underage child as a beneficiary on any of these documents. So when you have an estate plan, a will, a trust, what have you, a firm like ours is going to not only tell you you need to fill these out differently, but we're going to help you do it and make sure that those are maintained. And for a lot of people, the most money that would be generated when they pass away could be a life insurance policy. So you're telling me that that's not even going to go according to their wishes. So very, very critical. We've also had people lose homestead exemptions. This was with a living trust where they actually got it signed correctly. So at least there was that. But then they filed their deed for their home to go to their trust. But it's a very simple thing that we know to do, but they lost their homestead exemption. If you're in Texas and you're a homeowner, you know a homestead exemption is a really big deal. So just lots of messes. I could go on and on about different examples of how basically what we call cut rate planning, whether it's the DIY, the online forms, these legal programs, and really, even if you're only looking for the cheapest firm out there, this is the stuff that you're sacrificing, and it's not ultimately going to get you where you want to go, which we're about to kind of wrap up here and go to the next segment here, leads to the chart that I have been talking about. So this is something that I like to put together, that we like to show people to kind of look through all the different options that you have here. So, the first option here is what happens without anything. We've talked about that. What happens when you have a will? And we say will plan because know that, and when you work with a firm or an attorney, you should be asking about all these different pieces, but it includes a living will, a directive, medical and financial power of attorneys, HIPAA medical release, declaration of guardian, appointment of agent to control disposition of remains. If you have a minor child, you can do a designation of healthcare agent who can make medical decisions for them if you're unavailable, because you can appoint a guardian in a will, but if you are out of town or injured yourself, that doesn't matter. It's not saying who can make those decisions for your kiddos. So when we talk about this and we talk about all the fees associated with it, know that that's what we mean by plan. So we're not talking about just a will. We're not talking about just a trust. It's a will plan that includes all of this, or a trust plan. The cost of the plans we're going to talk about. This is some general ranges, but it also alludes to some of the specific things, the choose your own adventure plans, which is something new Burch Law is rolling out. So the best part of no plan is the very top one. It costs you nothing. Congratulations. Then everything just kind of falls apart. So probate and this is just if you have a home, a bank account. I'm telling you, it can cost up to $7,000 per person, if not more. So, if you're a married couple, multiply that by 2. Total legal fees, because now we're talking about, well, what if we have to get a medical proxy appointed? What if we, don't have a power of attorney? What if we have to go through a guardianship if you have dementia or Alzheimer's or a brain aneurysm? So total legal fees truly that you could easily get to almost $30,000 if you needed all of these without having them. It can take up to 9 months to even get a probate hearing if somebody passes away without any sort of plan. That means accounts are frozen, things are locked up, you can't sell a house or transfer a house. It's just a total mess. If you factor in missing medical powers of attorney and all of that other stuff, it can take years. And then who gets your home? State of Texas decide. Who gets your money and assets? State of Texas decide. Who's the guardian of your kids? State of Texas. When do kids get money? Age 18. Sounds great, right? And privacy. It's a complete public record. I said that you'd have to get 2 friends or people who knew you to testify to your marital history, kids, assets, debts. Well, all that's also going to be a public record. So pretty lousy plan. Now with a will plan, you see, well, it's going to cost something, right? But look at what it starts to save. You still, remember, a will has to go through probate court. I told you it makes it less expensive. So probate can average around $3,500, maybe to $7,000, but that's not really with the solid will. That's if you, only have a copy of the will or waited 4 years or there's something wrong with the will. It's really more on that lower end. It can take about 3 months to get a hearing, so definitely faster. Since we're presuming with a will plan you have all the powers of attorney, then it eliminates all the other complications. And this is where it gets really great. Who gets your home? Who takes care of your kids? What age do they get it? Money and assets, where does it go? You're deciding all of that. A will is still a public record, so the actual contents of the will and an inventory of your estate may be required as well. So remember, we talked about that revocable living trust plan. It's going to include all the powers of attorney and these other things. Like you see, it costs a little bit more for that. But if you're good at math, you can see how much it's saving. So what are potential legal fees? Nothing if you do it right. What are the court time delays? Nothing. Just like a will plan, you get to decide on all of this stuff. And it's also private, no public record. So 9 times out of 10, a trust plan is going to be better for people, but there are people who are like, I want to get a foundational thing in place. I understand the risks of probate, but let's get something started. But really, it's worth the money and really the time and work. And that's one of the critical pieces about going to a qualified law firm, is to make sure that they're going to guide you on all the other things that need to happen. All right, so we're about to wrap up here. I want to, that's kind of the legal educational piece that I wanted to do. Now I want to talk to you about something specific with Burch Law. So let's talk about the choose your own adventure plans. And this is what we're doing. Now I want you to remember back to the poem that I read, The Dash, and that this isn't just about depressing end of life plans. This is about who you are and how you want to be remembered. And when you look at the statistics, there's about 70% of people who don't have a will or any estate plan. Then when you factor in the percent of people that either have something that's out of date, out of state, or just cut rate. So by that we mean the do-it-yourself forms, the legal kits, the legal programs, and all of that we've been talking about. That's got to be another 15%. So we're talking about 85% or more of people who don't have a sufficient plan. So clearly, up till now, because this has been going on almost since the beginning of time, the traditional way that law firms provide estate planning isn't working. And one of the ways I think is because they want you to fit into their one standard way of doing it, which is the whole purpose of this. But two, I also think, and it's why I wanted to talk about legacy and the dash and everything the get-go, is I think that they focus on the doom and gloom and they don't really talk about how this can be a positive, a cathartic, a comforting, and even inspiring experience of how you're going to make sure people are going to be able to honor you and not be dealing with mess or family fights. So I decided to call these plans the Choose Your Own Adventure plans. I don't know if I've got any other Gen Xers, but I grew up on these books where you could, read to a certain passage and then it'll say, for this, go to this page, this, go to this page. So the idea behind it is really to try and significantly reduce that 85% and not just provide Texans with the plans that they want, but the way they want it. So unlike other law firms, you don't have to fit into this standard way of how we do everything. These plans are really designed with the degree of guidance you want and need, and the fees are based accordingly. And if you end up needing more assistance, you can pay for what you need when you need it. So you actually get to influence what it will cost. So there's 3 different levels, and know that if you reach out to us and decide to have, and that's part of what we're going to offer here in a moment, a complimentary no obligation discovery call with one of our qualified client concierges, then they're going to be able to deep dive, and don't worry about remembering everything on the screen. We have all of this as charts. But the question, the way that I have termed these is, the question is, how do you want to be remembered? So the starting plan is the estate defender. And at the very least, you've defended your estate against the dangers of probate chaos. And this is really for people. This is not what we would highly recommend for everybody, but we'd recommend it over anything else that you would do outside of our firm. It's for people who are otherwise not going to do any planning, or they're going to try and do it on their own, or they're really just focused on cost, but they still want something that will work. Well, this is far more than something, because this is going to be superior to anything that you're going to get from the DIY Forms Legal Services or cut rate law firms. Then the middle plan is the legacy protector, where you have protected your loved ones and your legacy by not leaving a mess. So there's, if you look at the check marks, there's more review time, drafts, more counsel, more guidance. That's what you're getting. Also, it's somewhat asset based. So when you're doing a trust and you've got maybe a home and a rental property, like a lot of that is included within this. And again, it's up for us to help guide you as well as what plan we think is the most time and cost effective for you. And then our most highest optimized level plan is the superhero. You have saved the day, everybody, and you have done all you can to ensure that everything will be as easy as possible and you get to be the hero of your own story. This has the most guidance, the most access, the most options. For those who really like a lot of hand holding going through this, who perhaps have more unique circumstances or wishes, or who may be more unsure and they want to go back and forth and have some redrafts, then the superhero is really going to provide the most support for them. It's also particularly valuable and cost effective for those who have multiple real estate properties, rental properties, property out of state, or if you have businesses. It's also a great choice when you have key advisors like financial planners, CPAs, with whom you'd like us to consult with, because that's what's really built into this, and it's at a higher tier. But I want to tell you before we look at the next slide here, is that no matter which plan, Choose Your Own Adventure plan, you select for yourself, they're going to get thorough and comprehensive planning. Let me go ahead. Well, I'm going to wait. I'm going to read this first. You're going to get a law firm with decades of experience in estate planning and probate. It's attorney drafted and attorney reviewed for Texans by Texans. Everything is confidential and an accountable attorney-client relationship. We're going to make sure that you've got signing guidance. We provide notaries and witnesses in-house, or like I said earlier, we'll make sure that they get signed correctly off-site. You get originals and your electronic signed documents, and you're going to get instructions and insistence on how to set up beneficiaries. You get this exclusive FAQ resource where if you want to know more of what the legalese is, you can click on it and read through it. I've never seen anybody put anything like this together like we have. And then we also have, this will be a segue to like the very last thing before we wrap up and see what questions we have, the CYA organizer. That's Cover Your Assets organizer. So this is a tool that we provide for you to put together usernames, passwords, people to contact. What's your phone lock screen? What's your computer code? What's the combinations to your padlocks? I mean, what streaming services do you have? Just all these things that really bog people down when they are trying to handle something for a loved one. Then there's always this option to, I'm going to show a slide here. It's not the next one, but the one after that, called our exclusive CYA plan, cover your assets plan, where there's 3 different levels of membership, and this is ongoing support. So what we're talking about now, the choose your own adventure plans, is getting the estate plan in place, is getting the wills, powers of attorney, trust, all of that in place. Then once it's all done, which is what is encompassed here, what about continued help? What about continued guidance? So we have an optional membership yearly subscription program I'm going to explain in a second here. So you can see what, and again, this is a tool that we'll provide to you when you reach out and want to meet with us one-on-one. But this is what is included with in the fee ranges. So I read this list to you, what's included. These are the kind of fees, flat fee that you can expect. And then, like I said, you get to choose if you need a little bit more assistance or whatnot, what the additional fees will be. And again, we really help talk to people about, okay, you want to do the estate defender, but you have all these questions and you think you might have to redraft a lot and you have 5 different properties. You can do the estate defender and pay for that time a la carte, but you're probably going to be more effective with the legacy protector plan. So again, don't get too bogged down in what works for you. This is more seeing that you've really got some options from a top-notch quality law firm, if you're in Texas, that are going to provide you different kinds of points. And I realize it's still not going to be as inexpensive or as quick as you want, but it is guaranteed to save tons of time and money. Think back to that chart, and heartache for your family when the time comes. So, and we'll go over that again. So let me talk a little bit before we open it up for questions and I give you some information on what to do next. So the CYA plan, the Cover Your Assets subscription plan, again, all these charts we can provide to you. This is a supplement once you get your plan in place. So if you want more help, more assistance on an ongoing renewable basis, you can. Our basic plan starts at $50 a month, or if you get a 10% discount with all these plans if you pay in full. You're going to get 24/7 online portal access, emergency access for yourself to your documents, as well as any of the emergency contacts that you want. It's going to include an annual review of your plan where we talk to you about, okay, what's changed? What's this? So for example, if you have a trust, you sold a house, you opened up a new bank account, you started a new job with beneficiaries, and we'll work through and guide you on that. We have information sessions. Remember, I told you I'm very passionate about all the beneficiary information and getting those set up. So we have about once to twice a year seminar like this where we'll go through and give some general advice. And if you need some help with that CYA organizer to get that information together, we'll do that. The plus, the middle tier, is $75 a month, or $810. This is every year. And it includes everything in basic, but you're going to get 2 times. We're going to review and go through any life changes. And if you need to update your plan during your membership, 50% discount on any additional plans. So then there's the complete $100 a month, $1080 a year. It includes everything in plus and basic. We're going to have quarterly check-ins where, how are things going? Have you gotten everything set up? How are your bank accounts set up? If you want us to meet with your family to discuss your plan, what to do, we'll do a more deep dive into what specific bank accounts, assets you have. And then we will follow up with you. We'll help fill out forms. We'll talk to financial advisors or bankers or anything that we need to do to actually get these things set up the right way. And there is no charge during the term of your membership if you need to update and change your plan. Now, if you add other things, like you're getting a whole nother, like you're setting up a business or something, well, that wasn't part of your original plan. But if you are making any changes to your wills, trust, powers of attorney, there would be no cost. So it's something optional that we walk people through. That's our CYA plan and ongoing support and assistance plan. All right, let me wrap up here and we'll see what questions we have. So far we've discovered it's critical to get a solid legal plan together. These online forms, will kits, and shortcuts are a false sense of security, and they're not worth the paper they're printed on. And there are additional planning options, such as a living trust, such as exclusively with Burch Law, the CYA plan, that can save your family time, money, and heartache. So it is some doom and gloom. I'm not telling you it's not any, but it's important to get a plan before it's too late. The worst thing you can do is sit on this and do nothing. Remember, it's time. Time is always running out, no matter how much time you have left. And it can be it's never too early to plan, but oftentimes is too late. So instead of the doom and gloom of this, you can turn it into be a superhero to your family. All right. So I showed you that slide with some common things we hear when things weren't done or weren't done properly. This is what we hear when people have a proper estate plan. My mom made this so easy. I never thought this would happen so soon, but I'm so glad we did this ahead of time. We're planning a trip to Hawaii next month to scatter his ashes. Having this all planned has made it so much easier for me and the kids, and we can focus on healing. So what do you do now? If you are interested in finding out more information specifically about Burch Law and the Choose Your Own Adventure plans, you can book a complimentary discovery call. We have a very limited number of space. I know Sarah is going to post the link. So you have the QR code. Sarah's going to post in the chat a link to where this goes, where you can book today a discovery call. We only have a few slots open. So do this now, or if you're watching the recording, hopefully there's some left. Or call us directly right now, or send us a text message. Say, call me right now. That's the way to make sure that you can jump on this and get it done. So remember, the right time is always now. I just said it's never too early to plan, but it can be too late. You don't have to have perfect answers to start, okay? And if you don't have a will, state of Texas has one for you. So now I'm going to turn it over to questions. I do want to go back here just in case anybody needs another quick second to scan that, or to get the link in the chat, or that is our phone number. Sarah, why don't you go ahead and put the phone number in the chat as well? And you can call directly. Operators are standing by, or you can even text us there. So I want to thank everybody for their time and attention. And I am now going to turn it over to the chat and see questions. Okay. Okay, great questions that we have here. Do the assets and income in trust get taxed? So a revocable living trust works no differently if it's in the name of the trust or not in the name of the trust. So if you have an investment account and you're accruing interest on it, then you will be taxed the same way with a revocable living trust that you would be if we're out of a revocable trust. So no differences there. So beneficiary, whether it's trust or not, let's talk about inheritance tax, okay? So in Texas, there is no inheritance tax, meaning if your estate is worth $5 or $5 trillion, it's going to go tax-free to your beneficiary. It's kind of wild, right? I mean, if you have a $10 million bank account or a $10 million life insurance policy, and you've named, your best friend as a beneficiary, tax-free. All right. We are subject to the federal exemption amount. That is always in a state of change. It has been pretty high lately. It is a new year, so I don't have it memorized, but I can tell you it's going to be, it's probably around, I think, 13 million or 12 something right now for, meaning if your estate is below that, there will be no taxes. So for those who are in the, 0.02% that might have estate taxes, there are additional things that we can do to offset that or eliminate that. But just the existence of your assets or them being in a revocable living trust. Now, hear all those words because there's irrevocable, there's a lot of different things that work differently, but the standard bearer revocable living trust, the way that it's written, it doesn't have any benefit or any tax problem. It's not treated any differently, is what I'm trying to say. How can I find out if there is an existing will that I'm not aware of? I'm going to guess that you might mean for somebody else, but I'm not really sure I understand what that means. Because hopefully, like if you're talking about yourself, then you know whether you have a will or not. But I wouldn't put past anybody not knowing. But that can be a huge issue. Is we deal with that where somebody passes away, I don't know if they have a will, and it can be a real problem. I mean, you have to go through paperwork. You have to call firms. Like we've had people call us because there's other attorneys that have the last name Burch, or maybe they went to a seminar of ours and they have a brochure and they're like, did they ever get their will done? Sometimes they can be recorded in the county, but that's really old school. I don't recommend doing that. But those are ways you can see. And it's one of the reasons I'm going to keep beating this drum of going to a qualified law firm, doing things, going with a firm that does extra things like the CYA plan, like that, where we talk to you about where have you left this paperwork? Have you made sure people know that you've done it? Part of the CYA plan, the complete plan, is we actually will prepare a document for you where we'll send it to your loved ones, whoever you tell us to, that says, I've done this, you're this role, here's where I keep my documents. It's also why we have that portal where, as part of the CYA plan, where you can provide us contacts to have emergency access to the electronic copies. So that can be an issue, and it happens all the time. It's called a lost will, and there's lots of messes that come from that. Okay. Great question. If you move away from Texas, which, why would you ever do that? It's such a silly hypothetical, right? If you move away from Texas after you have a trust in place, what needs to happen? Let's just talk generally when you move. So it seems kind of strange in this day and age with how mobile of a society we are that, yes, everything is very state specific. But what do we mean by that? Well, if you move to a different state, your will, trust, medical power of attorney will be honored there. It doesn't suddenly become invalid. However, we all have specific laws that if your documents aren't written with those specific laws, then it may be an extra burden. There may be extra hoops, time, expense. So it is best that if you do move to a different state, that you do have somebody review it, and you might need to update, and you might just need to redo the whole thing. And I'm going to talk about that in a moment, perhaps, if we have time. But with a trust, that's actually more mobile. And the reason why is, remember what we talked about is a trust is written to not be subject to the state probate laws. So a trust is actually something that is less likely needed to be changed or updated to be in compliance with a different state's law. What I wanted to talk about that this question made me think of, and I'm surprised it didn't come up because I bring it up all the time, is when we're talking about costs and we're talking about the cost of redoing an estate plan, you know, you've really got to focus on the value of what you're doing. And I like to use the example of homeowners insurance, which for most people in Texas is $3,500, $4,000, and you pay that every single year, whether you have a claim or not. And even if you do have a claim, there's a huge deductible that's going to be thousands of dollars more. But if you're like most people, it's that peace of mind, it's that insurance, it's that guarantee that if something happens. Well, the only difference between homeowners insurance and an estate plan is it's if something happens with homeowners insurance. With an estate plan, it's when something happens. So certainly it's worth paying that cost once, 3 times, maybe 5 times your entire life to make sure that you've not only protected your home, your assets, but to make sure you're not leaving a mess for family and loved ones. Okay, I think we had another question come in. Keep the questions coming in. I'm about to wrap up. You can always reach out with more questions. Do post again in the chat, Sarah, the link for scheduling, because we only have a few slots available for that, just for people who are attending this. So your father-in-law has a valid will, but his date of birth and other information are incorrect. Does that make it a valid will? I don't want to answer like valid, like would it be upheld? The bottom line is, will that cause extra delays, extra expense, and some problems? Absolutely. It absolutely will. Funny, if you had asked me that question maybe 10 years ago, I'd say, oh, probably not a problem at all. It's just, if they don't have the right name, if you've got Lorie L. Burch, but not Lorie Louise Burch, that's even causing some issues now. So we painstakingly go through and we'll add AKAs. It's amazing how many people aren't really sure of what their legal name is. Like, did I keep my middle name when I got married, or did I make my maiden name my middle name? Oh, I use both. I've got a bank account that says this and a driver's license that says that. And so we try to make sure that we see that for you, because absolutely that can cause issues. What happens to a trust if a couple gets divorced? The same thing that happens with everything. You're going to have to divide up the assets. We get asked this a lot. You can dissolve the trust, like revoke it. But if you have separated all the assets that are connected to the trust, it has the net effect anyway. Because if there's a trust that doesn't have a home, a bank account, or a beneficiary designated to it, then it's like the trust doesn't do anything at all. And in fact, we do recommend, and we do this all the time, where divorced couples would update their own individual plan. And when you create your own new individual trust or will or estate plan, it'll say anything previously is hereby revoked. So it's kind of taking care of two things at once. But being in a trust doesn't add complications to separating assets in a divorce. But let me tell you this, that doesn't mean title companies, banks won't say that they're totally confused and don't know what to do, and this is a problem. When your clients of Burch Law, when your clients of firms that have that attorney accountability for you, before you get worried or concerned, just call us. A lot of the time, it's just explaining the law to people or being there for you and helping explain that. All right. Any other last minute questions? Otherwise, I appreciate all of your time. I hope that you found it helpful. You'll get the recording if you did register for this, and hope that you use this year as a time to get this in place so that you can leave a legacy and not a mess, because you don't have a will, the state of Texas has one for you. Good to see you all. Thank you for joining, and hope to see you in the office soon.